name is Tim Fugate. I'm the Chief Operations Officer for BLI Contract Security. Today I want to talk about liability, and I am making this video so that I can direct it toward not only our state and federal clients, but also our private clients. When I go out and I talk with my current and prospective clients at the federal, state levels, private companies, and individuals who are looking to contract a security firm, I am shocked to learn that very few truly understand premise liability. I am even more shocked to learn that companies who had security before us have never discussed premise liability with their clients. When our federal government hires physical security companies through the Government Services Administration, those companies have to prove that the officers they will send in have formal training per the SOP, such as active shooter, premise liability, arrest and detainment, report writing, etc. So when we talk about liability, we also must acknowledge that under civil liability, we have tort claims which can be used to sue a business or a corporation for inadequately trained security officers, or security officers not doing anything when a situation arises. So when we talk about premise liability claims, we are talking something wide-ranging, from your slip and fall accidents to intentional shootings during a robbery. Recent cases at the Supreme Court level have detailed a business owner's liability for criminal acts conducted on their property by third-party criminal actors. And the implications of the decisions are important for business owners to understand. Customers of a state or federal building and private businesses are considered invitees. This distinction is very important because business owners must provide a higher duty of care to ensure not only the employees but also the customer or invitee's safety, be it in a building or on any of the grounds owned by this agency. Outside of the classic hazards for slip and fall claims or injuries from lack of maintaining the premises, one area of liability business owners do not consider for criminal acts of third parties or inadequate security claims. In Bass versus Gopal Incorporated, the court held that a balancing test should be applied as to whether a business owner should be held liable for the criminal acts of a third party on their premise. The balancing test seeks to balance the degree of foreseeability of harm against the burden of duty owed by the business owner. Ultimately, the courts ruled a business owner has an ultimate duty to take reasonable action to protect its invitees and employees against the foreseeable risk of physical harm. Now, what does this mean in layman terms? Under the court's ruling in Gopal, a business owner is liable for injury sustained by customers or employees during the course of a robbery or other criminal act. When we look at Gopal, we also have to acknowledge another court case, which was Lord versus D&J Enterprises. This was where the South Carolina Supreme Court unequivocally held that the Gopal decision applied retrospectively as opposed to prospectively. The court decided the Gopal decision fell into the latter category because that decision created no new duty for a business owner, but rather clarified the test in assessing the scope of that business owner's duty. In Lord, the plaintiff presented expert testimony by a security consulting firm that I am very well familiar with regarding the foreseeability of a crime and whether an armed security guard posted at the entrance instead of an unarmed security guard being posted at the entrance of that business would have deterred the criminal act. Using the Gopal balancing test, the court in Lord decided that this was enough to create a question of fact for the jury and allowed the plaintiff's case to survive a summary judgment motion. The Lord and Gopal decisions arguably make it easier for plaintiffs to survive a summary judgment motion and present their cases to a jury. The dissent of Lord, written by Justice John Kittredge, stated that today the court holds that a merchant has a duty to provide a security guard where random acts of criminal violence occur even miles away from that business. This decision should make business owners think twice about the security measures they employ. Also, it should make them think about the training that your security company provides to their security officers and the services it provides at your place of business. The last thing a business owner wants is to be in front of a jury explaining why he or she did not spend a little extra on security, and the jury will most likely be less sympathetic to the business owner than the wounded victim. With a plaintiff's ability to survive a summary judgment made easier by Lord and Gopal, this is exactly the type of situations in which business owners may find themselves in if they are not careful with who they hire to provide professional security and the business location. I'd like to thank you for your time today, and if you have any questions, comments, or would like to reach out to us, our information is at the bottom of the video. Thank you.